Hello, Assalamu alaikum. Welcome back to this next video in the series of videos that we have been doing for your guidance and information. Just as ever, to remind you that these videos are very much for your guidance and information. They do not constitute legal advice. If you require specific legal advice, then please contact our team who will be more than happy to assist you. In today's video, I want to give you information about the distinction in the 5-year and the 10-year route for partners and parents. There's a lot of disinformation out there on social media circles about this, and it's very important that you are rightly guided in relation to these applications to avoid losing unnecessary fees. Before we talk about the distinction in the 5-year and the 10-year routes, I just want to provide you with a brief overview of the main requirements that a partner would need to satisfy in order to secure leave to remain in the UK as a partner, or to secure an entry clearance visa from overseas on that basis. So the first requirement you need to satisfy is to meet the suitability requirements. There are relationship requirements, that you've either contracted a valid marriage, that you have lived together for at least 2 years, or if you're applying from overseas, that you're applying as a fiancé and intend to get married within 6 months. Additionally, you need to show that the relationship is genuine and subsisting, and that you intend to live together permanently. You need to meet the financial requirements, and typically if there's a partner only with no dependent children, that you have an income in excess of £18,600, that you meet the language requirement, and you have adequate accommodation. Additionally, if you're making an application from within the UK, then you also need to meet the immigration status requirement to prove that you have current leave to remain in the UK for at least 6 months beforehand. In relation to children, the main requirements that need to be met by a parent of a child are that they meet the same suitability requirements, they need to meet the relationship requirements, proof that they're related to the child, that they're having contact with the child or the child lives with them, and that they play an active role in the child's upbringing. In relation to the maintenance requirement, there's no minimum income threshold for that. You need to show that you can be adequately maintained, you have adequate accommodation, and the language requirements are the same again. And finally, if you're making an application from within the UK, then again you need to show that you have had a visa for a period of at least 6 months beforehand. In relation to both those categories, either as a partner or a parent, if you meet all the requirements in relation to suitability, the relationship requirements, maintenance, accommodation, language requirements, and the immigration status requirements, then you would be eligible for a visa under the 5-year route. You would always be given a 30-month visa, but it would be under the 5-year route, and following one extension, you would ordinarily be eligible for indefinite leave. Now then, the big question is, when does the 10-year route become relevant? The 10-year route becomes relevant when you can't meet some of those core requirements. Now, essential prerequisites, whether under the 5-year route or the 10-year route, are that you meet the suitability requirements, that you meet the relationship requirements. But if you cannot meet the financial requirements, the language requirements, the accommodation requirement, or the immigration status requirement, then you could still possibly get leave to remain either as a parent or as a partner, but in those circumstances you would be granted leave under the 10-year route. In order to get indefinite leave after 5 years, and that is the quickest way of getting indefinite leave, you need to have met the full requirements of each of the rules, and secured leave under the 5-year route for 30 months in the first instance, extended on the same basis for a further period of 30 months, and then you can secure indefinite leave after 5 years. But if at any stage you did not meet any of those requirements and you were switched to the 10-year route, then you can't combine these periods for the 5-year route to settlement, but you can combine these periods of leave towards the 10-year period. Okay, let me just further clarify that for you a little bit. So if you start off on the 5-year route, and you're granted leave for 30 months, at the end of those 30 months, you make a further application, but for some reason you can't meet the finances or you can't do the next language test, and you're switched over to the 10-year route, then essentially you will have to complete 10 years residence in the UK before you are eligible for indefinite leave. On the other hand, if you started on the 10-year route and you're granted leave for 30 months, and you may have started on the 10-year route because you were here in the UK without a visa and you didn't meet the immigration status requirement, and you're granted leave under the 10-year route for 30 months, you could immediately make an application to vary your leave onto the 5-year route. And now that, given you already have leave to remain in the UK, you would meet the immigration status requirements, and therefore by making this further application to switch, you could immediately shorten the period of leave required to get indefinite leave. So once you're granted leave, if you would make a further application within, say, 2 or 3 months, your 5-year period would start from the time when you're granted that new period of leave. So where you are given leave under the 10-year route, it's always worthwhile thinking about whether or not it's appropriate for you to immediately switch your leave to the 5-year route. The downside with that is that you would need to pay all the Home Office fees all over again. Whenever you do come around to making your applications for indefinite leave, it's very important to get complete clarity on your historic immigration status. It's important and essential that you're able to prove that you've completed 5 years continuous residence in the UK under the 5-year route. And if you can't do that, then you will need to complete a longer period of residence before getting indefinite leave. It may be that you were initially granted leave under the 10-year route, and you completed your first 2.5 years and then decided to switch to the 5-year route. In that way, you'll be eligible for indefinite leave after 7.5 years. But in other cases, you will need to wait 10 years, and there is no shortcut as such on that. But whenever you do think of making an application for indefinite leave, it's very important that you get clear advice and you're clear about your immigration history. Otherwise, you risk losing significant sums of money with a wasted application for indefinite leave. Finally, I should clarify that there's one particular category of applicants that wouldn't qualify for indefinite leave sooner than completing 10 years. And that's in cases where neither partner or parent of the children has settled status or is a British citizen. So, for example, in cases where you have both the parents have been granted leave to remain in the UK based on their children having been in the UK for 7 years or having acquired citizenship after 10 years, and they're both applying for further leave based on their children, and neither has settled status themselves, those applicants will always need to complete 10 years before qualifying for indefinite leave. If you require any support and assistance with your applications, then please contact our team, who will be very happy to help you. I hope you found this video helpful. Please like, share and subscribe.